Good morning, everybody. My name is Jim Marlin from Attorney's Title. I have only about a half an hour to tell you what I can about title insurance. I know this is the favorite part of the topic. That's why you all came, because there's nothing could be more possibly exciting than title insurance. I know that. I could speak about this topic for hours on end, but you won't have to suffer through that. I'm going to limit my remarks to about a half an hour. What I would like to do today is there's two handouts in your folder that I prepared. The first one is a narrative. It's a discussion of what a title insurance company does, where they search, what they look for, and it's a description of these various items. We don't have time to go through that today, but I would encourage you to read that as a background material sometime. The second handout is a sample of a title insurance commitment and policies and a couple of indemnities. Again, I won't have time to go through all of those today, but what I want to focus on today is looking at the title insurance commitment and give you some ideas about things that you probably never stopped to think about before, but probably should. All right? If you're representing, how many brokers in the room? Not, you don't want to, you aren't any, or you don't want to admit it, or, okay, I thought it'd be, what about bankers? Okay, a bunch of lenders in the room. Okay, so when you're getting your title insurance policy, of course, very briefly, the process is as follows. There's one commitment that's issued by a title insurance company. That's the result of getting a search and reading through it and figuring out what's important and what doesn't matter anymore. If every single document that was discovered in the course of the search were reflected in the title insurance commitment, it would instead be an abstract of title, which looks like a very imposing and helpful document. Actually, it's a shorthand version of every single document that is in the chain of title, provided to the customer with more or less directions. Figure it out for yourself, or have an attorney write his opinion on it. But it's a copy of every single document in the chain of title. The title insurance commitment, on the other hand, an examiner goes through it and figures out what's still relevant. We don't tell you about mortgages that were paid off 30 years ago, or covenants, conditions, and restrictions that have expired, okay? So the object of the game is look at the commitment and see what kind of remedial work needs to get done in order to make this close. Our industry estimates that 1 out of every 5 title searches reveals something that's going to require some kind of attention to fix. Title insurance protects the buyer and their lender against ugly surprises. It tells you before you go to close what problems there are. A mistake, an urban myth, is a title insurance company insures against problems that we don't know about. The fact of the matter is, when we do our title search, we look for things that are wrong, point them out to you, and tell you these are the things we are unwilling to insure over. Okay? So now, before the closing takes place, a decision should be made. Can we live with this, or are we going to take some steps to fix this problem? There's not any kind of title problem that can't be fixed with documents and or money. Easy for me to say, not my money, but nobody ever died at a real estate closing. All these problems can be fixed. Title insurance companies are not there to try to blow up deals. We're there to point out problems to be addressed and some intelligent discussion made how to fix them. Also, as I go through the commitment, I want to point out to you that without any additional money, in many cases, some with extra money, many title insurance risks that would normally be excluded from coverage, accepted from coverage, can be obtained, and sometimes that's very important. The second outline with the sample title insurance commitment, I'd like you to look at page 3 for a second of that outline, the one of the title insurance commitment. There's one, like I said, there's one title insurance commitment issued prior to a closing, typically followed by 2 title insurance policies. One for the owner, the new owner, the buyer, and one for that buyer's lender. They insure different things. They insure, of course, the title, the ownership, and the owner. They insure the priority and enforceability of the mortgage for the lender. I would tell you that the enforceability of the mortgage by the lender isn't something that keeps title insurance companies up at night. Typically, the lenders we deal with are institutional lenders using American Bar Association forms. That isn't something we're going to be too concerned about. What the lender is concerned about is the priority of their loan. when we foreclose, God forbid, we used to say, we issue these policies and there's no claim unless there's a foreclosure, and that never happens. Well, we don't say that so much anymore, and that dramatically changed over the years. And now many lenders do in fact become the owners, and now they're trying to become sellers and REOs, but that's another whole subject for another seminar someday. The point is, there's one commitment and two policies, and the interests are not necessarily exactly the same. Title insurance companies are much easier to please on issuing loan policies for some reasons I'll go into a minute. So we're very likely to clear or delete exceptions on loan policies with no extra work or very minimal extra work and give that lender thereby some extra coverage, okay, that is not going to be provided to the owner. So unless there's an attorney for the buyer or their broker there to instruct them on this, some coverage is not going to be obtained that they might want to have. Let me illustrate a few of those things. On page 3 is a Schedule A of a title insurance commitment. Title insurance commitments, no matter what company you're dealing with, are always divided into 3 sections. Schedule A, Schedule B1, and Schedule B2. I should also tell you that this title insurance commitment form and the policies that get issued afterwards, the commitment is kind of like the before the closing. The policies is the situation after the closing. When everything's been done, documents have been exchanged, money's been exchanged, the deal's been closed, then it's the after, then a policy gets issued. The point is that all of the commitment forms that you will see from any title insurance underwriter or agent, whether it's the commitment form and the policy forms, are going to be identical. Not just similar, word for word identical. Those are called ALTA forms, A-L-T-A, American Land Title Association forms. They're word for word exactly the same. Every so often, the American Land Title Association, which is comprised of title insurance companies, get together with large lenders like Fannie Mae, Freddie Mac. Those are bad words these days, but in any event, every so often, the American Land Title Association Forms Committee revises the forms to take into account changes in the industry, customer demands, modernize them. In my career, we started in the 70s. There was a 1970 policy form, there was a 1986 policy form, a 1992 policy form, and then they were all redone in 2006. Long story short is every time the policies get changed, there's a give and take between insurance company and customer. The 2006 policy cover was all consumer oriented. Okay, so the 2006 policy cover is the only kind any reasonable lender or buyer would ever want to consider having, and that's the only kind that's being issued right now. The point is you don't have to compare one companies to the other. They're going to be exactly the same, including the commitment form. Back to page 3. Schedule A you should think of as the informational page. All you need to do, for God's sakes, please do, check for accuracy. All right? When an order gets placed with a title insurance company, they'll tell us who the buyer and the seller is. Frankly, our position is that's okay. We'll tell you who the seller is. After we do the title search, we'll tell you who's entitled. It's not John and Mary Smith. It's the Smith LLC that the family started, or it's the trust they put it into. Everybody forgot about it. So we'll tell you who's entitled. But in terms of who's buying, we have no way of knowing that. You got to tell us. So when the proposed insured, and number 2, picks up, is this how the names are supposed to be spelled? Do they want middle initials in there? How do they want to take title? Things like that should be addressed with the proposed insured or the buyer, because that's not of record yet. It won't be till the deed to them is recorded, right? Okay, let's back up a second. The effective date. What's the big deal? How could that be anything I want to be talking about today? I can't tell you the importance of this. Everybody is familiar in their life with all kinds of insurance, right? Car insurance, health insurance. Let's talk about car insurance for a second. I buy a car, I get a title insurance policy. It says the effective date is February 18th. That means from this day forward, I'm covered for accidents. Nothing that happened 2 days ago is covered, right? Every other kind of insurance has an effective date. This is when the insurance starts. With the effective date on a title insurance commitment, this is when coverage ends, okay? We're telling you that as of that date, here's what we found. And it will always be behind. If I go to the Register of Deeds office this morning and record a deed from me to you, I go to the registry and they take it, they record it, they give me a document number, and they tell me the effective date of the search is up through today. As soon as I walk away from the window, I don't know that the next person's coming along who's recording a document with the same legal description. It's always going to be behind. You see what I mean? So that what we do as a title search company, as a title company, is we do a search and we pull the plug. We say, as of this day, this is what we found. Also, if you go to any registered deeds office in any courthouse in the 72 counties in Wisconsin, you will always see two dates somewhere in that registered deeds office. One will be today's date, which you probably know anyway, but the other one will be, it'll say posting date or effective date or track date, some other date. The registered deeds will be saying, even though today is February 18th, our records are current, posted up through, say, February 1st or February 10th. In Waukesha or Milwaukee County, when it's busy, like in the refinance boom, that date might have been 2 months ago. Now, when I take a document up there, they look at it to see if it's recordable. Okay, they look, are the names printed under the signatures? Is there a legal? Is it legible? Is there a transfer return form? And they will record it, and they will give you a receipt. It's recorded as of today, okay? But it won't find its way into their system. It won't be posted in the proper real estate for however long it takes them to catch up, depending upon how busy they are. If you go to a small county in Wisconsin where 5 documents got recorded that day, there might be no gap at all. If you go to a busy courthouse, it might be significant. The point is, if you're going to a closing today on February 18th and you got a title insurance commitment, look at that effective date. If that's 2 weeks ago or 1 week ago, understand that the company is saying a week ago, this is what the status of title was. If there was a judgment recorded, docketed against the seller yesterday, that won't be here, and you're not insured for that. If, in the unlikely event, I was talking about the extreme cases, it's entirely possible that people sold this property yesterday, they're fraudsters. Okay, that deed isn't recorded yet. That's going a little overboard here, but it happens. Okay, if you're a lender saying this information is behind, well, in this county or the counties around here, I don't know. Can anybody tell me what kind of gap there would be in a recording in Eau Claire or, I don't know, probably not too bad. My point is this: check that date, see what it is, and if it's too far back, there's a way to address this. It's called a gap endorsement. Anybody ever heard of a gap endorsement? Do you order that typically? Do you get that? Okay. It is if I were in practice and I were a lender, I would insist upon that. There's a gap endorsement. There's a sample of one on page, in the same outline, on page 21 and 22. Page 21 is a sample of the endorsement. Page 22 is an indemnity we'll get from the seller in order to give that. What the gap endorsement basically said is, despite the effective date being February 10th, you're insured through the recording of the documents. There are actually 2 gaps if you think about it. If we sit down today on February 18th and we see an effective date of February 10th, we know that there's a gap between the 10th and the 18th, which is today. There's also going to be another gap between now and when the documents ever get recorded. That may only be a day or 2, but something could happen in that gap, right? A judgment could get docketed, a construction lien could get filed, there could be some kind of a notice of delinquent taxes, there could be some kind of a problem occurring during that, one of those 2 gaps. The bottom line here is this gap endorsement will insure you for that. The gap endorsement itself says there's a couple of conditions to this insurance. Okay? If we're going to give you this insurance, well, first thing is the seller, the owner at the time, has to give us an indemnity on page 22 that says, we haven't done anything to affect this real estate since the gap. We haven't been given notice that somebody's going to sue us. We haven't filed for bankruptcy. We haven't done anything that would give rise to a problem here. The second thing is, if we give you this insurance, you have to tell us before you close that you're going to close. Again, if we issued a title insurance commitment with an effective date of February 10th, you can rely on that information for 6 months. You could close 2 months from now. We send out the commitment, we don't even know you didn't close. So 2 months from now, you're going to close, you got to tell us, we're closing, so give us a chance to get closer to the effective date. You see what I mean? You got to tell us 2 days before you close, we're going to close, give us a chance to bring it forward. And then you either have to get the documents recorded yourself within 2 days or give them us within 2 days. In other words, if we're going to give you this gap insurance, you got to give us a reasonable chance to keep this gap minimal. Okay? but it's something I would absolutely insist upon if I were an owner or a lender. So that's my message on the effective date. Don't overlook that. The rest of the material on Schedule A, like I said, is information. Who the buyer is, who the lender is, the amount of a title insurance policy, that's the maximum amount of damages you can recover, not including attorney's fees, which can be added on. Most of the time, you're not going to be necessary to rely on the entire amount of insurance unless there was absolutely no title conveyed. Most of the time, the things that are turned into claims are missed taxes, missed mortgages, misjudgments, and frankly, just plain human error. Okay? The other thing that I want to point out on Schedule A is the legal description. Please pay careful attention to that. This is the real estate you're asking us to insure. This is the real estate that's going to be on the deed and the mortgage. Somewhere along the line, somebody should tell us, or somebody should tell the customer, what is this property? Are you getting lots 3 and 4? Did you mean lots 3, 4, and 5? Take a look at a survey. Take a look at a plat map. It happens sometimes. People think they tell the title insurance company lot 3, and they meant to include the vacant lot next door. We have no way of knowing that. Just because you own it, we don't know that you're selling it. And not to mention the fact, if you tell us to do a search on lot 3, we're not going to check lot 4 to see who owns it because we don't care. You ask us to check lot 3, that's all we're going to check. The point is you got to be careful about what it is this includes. Make sure it's your property. You're going to see subdivisions, lot and block. You're going to see meets and bounds descriptions. You're going to see certified survey maps. We don't have time to talk about easements today, but whether an easement should be included there, whether you're going to be insuring it, is a serious topic. It might be an access problem. I have several different whole seminars I could talk about easements on. We don't have time for all of that today, so I'm going to skip that for now. I also, before I forget, would encourage you and welcome you. I've been doing this all my adult life. I graduated from law school 100 years ago, and I've been doing this ever since. I work at title insurance companies as an underwriter, and I occasionally teach at Marquette Law School. And this is all I talk about, real estate conveyancing. And I actually enjoy it, as dry as it might be. My point is, if you have a question sometime on title insurance or anything else about a real estate deal, I would welcome you to call, and I'd be glad to share what I have, my experience with you. If you want to talk about easement sometime, give me a call, or anything else for that matter, okay? Questions so far? I'm talking kind of faster because I'm on a short time leash, but there's a couple of other things I definitely want to get to today. Page 4, Schedule B1. Schedule A is information on page 3. Schedule B1 on page 4 are requirements, not suggestions, not it would be nice. These are requirements. If we're going to issue a title insurance policy listing the owners and the legal description on Schedule A, these are the things we have to have. Okay? Number 1, there has to be you have to pay us for the premium for this policy. Well, that should go without saying. If you don't pay for the premium, you're not going to have insurance. I'm not going to spend time talking about that. The documents to be recorded are as follows. Now, this is going to be varied. We're going to need certain documents in order for us to issue a title insurance policy. Very simply, if there's going to be a proposed insured as Mr. Smith, we're going to need a deed from the current owner to Mr. Smith. If there's going to be a mortgage from Mr. Smith to the new lender, obviously we're going to have to mortgage in favor of the bank executed by him. The mortgage and the deed and mortgage are typically things we're always going to have. But don't stop reading there, because what you will also see in this requirements section are supporting documents to substantiate the authority of certain grantors, mortgagors. For example, you don't always have a natural person as the grantor in a deed or a mortgagor. It might not be John and Mary Smith, husband and wife. It might be an LLC. It might be a partnership. It might be a corporation. It could be a trust. It could be some legal entity. Okay, if that's the case, some of this material is of record. Some of these foundation documents are of record. Many are not. So, for example, if there's going to be a partnership conveying a piece of property, we're going to need to see a copy of the partnership agreement so we determine who the partners are and whether one or all 3 of them or 4 of them or 8 of them need to sign a document. Okay? So there are documents that we're going to have to look at so that we know that the proper people are signing the instrument. All right, so don't take that for granted. We want to know that the organization exists. We want to know that they've taken some measure, like if it's a corporation selling, did the board of directors get together, pass a resolution to sell the property? All of these things are going to have to be done before the title company is going to be willing to issue a policy insuring the grantee. And if everybody waits till an hour before the closing to read this, that's what causes problems sometimes, okay? Now I want to talk about a couple of exceptions. Schedule B1 is requirements, things that we're going to need in order to issue a policy. Schedule B2 are the problems. Not necessarily problems, they are problems in the title in addition to certain things. You see the printed stuff that's in schedule, that's a legal term I like to use, stuff. The printed material in Schedule B2, what you see in front of you are exceptions to coverage, things not covered, that appear in every single title insurance commitment before a search is even done. When we do the search, we find things in title that are unique to this particular legal description, like the current mortgage or mortgages, outstanding judgments, construction liens, things like that. But the printed material that you see right here are things that a title company says, we're not insuring you right from the beginning. Well, if you remember anything after this seminar this morning from my portion, I'd like you to know that all or most of these exceptions to coverage can be eliminated at no additional charge or a minor charge. For example, on page 5, if you will, there's another special exception, number 1, defects, liens, or encumbrances first appearing, blah, 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 blah. That's another legal term I like to use. That number 1 on page 5 is a title company saying you're not insured for things in the gap. Okay? Things that appear after the effective date but before the recording you're not insured for. Well, if you get a gap endorsement, that crosses that exception out. Okay? Now that, there's going to be a charge for that. I don't know what I can't remember, it's about $150 for a gap endorsement. There's a charge for that because the title company says, we will give you insurance for this. We have no way of knowing when it's a pure risk, which is something we don't normally do. So that's why there's a charge for that. But going back to page 4, with these other printed exceptions, I want to talk about those for a second. But I can't do that without also addressing page 6. Page 6 is oftentimes an overlooked document that should not be. It's an owner-seller affidavit. This is not necessarily uniform from title company to title company. I personally rewrote this about a year ago to be more up-to-date and fit our marketplace. It's an owner's affidavit. We're asking the current owner, the seller, to tell us things about the property that we cannot find of record. When a title search gets ordered, we go and look at the Register of Deeds office, look at the circuit court, we look at probate records, divorce records, tax records, public records, and find out what we can about this real estate and report it to you. There are a lot of things that will affect the title to the real estate that are not recorded anywhere, and we would have no idea. The most important of which, in my opinion, is what another subject of the seminar today is construction liens. Okay? Exception number 4 on page 4 has any lien or right to lien for services, materials, etc., not shown by the public records. Those are construction liens. Construction liens are the only kind of lien that has a retroactive effective date. Let me back up a second. If I have a mortgage on a piece of property as a lender and I record it on February 18th, that's the date my mortgage is in effect. If I docket a judgment I obtain against somebody, that's the date. When it appears of record, that's the date when it is effective against the real estate. With the construction liens, it's the opposite. Okay? If you hire me to do work on your house today, and I start construction today, okay, February 18th, let's remember that date, all right? This property gets sold 2 months from now, okay? I came to your house, did work, I put a new deck on your house February 18th, I finished it on March 18th. You sell your house on April 18th. The title search gets done. There's no construction lien filed. At this point, I don't even know that I'm not going to get paid. Okay? You hired me, I started on February 18th, I finished March 18th, you sell your house on April 15th. To you, you buy the house on April 18th, there's no lien recorded. He has 6 months from the last date on his job, which is March 18th, to file a lien. Here's the critical part. The effective date of that lien relates back to when he started the job, February 18th. Okay? Do you see the problem there? We didn't even know, but he has 6 months from the last date on his job to file the lien. And the lien isn't effective when he records it, it was effective when the work started. Now, lenders in the room. Good news, tidings of glad joy. A little late, but that's my message. In Wisconsin, which to the best of my knowledge is pretty sure still the case, Wisconsin is the only state in the union that has a statutory protection statute. That's 706.11 for the attorneys in the room. That statute says that a lender, most institutional lenders, 706.11 lists them by class, not by name, of course, but national banks, state banks, etc., they don't have to worry about this problem. Because if a bank or an institutional lender records their mortgage before the lien is actually filed, that mortgage has priority over the lien, even though the work started earlier. Okay? So that makes it much easier for title insurance companies in Wisconsin to give coverage over construction liens to lenders. So that on a lender's policy, with an institutional lender as the insured, this exception will pretty much automatically be deleted because we don't have to worry about it. Obviously, if there was a lien filed, we would have discovered it in the commitment, pointed it out to you, and it would have been paid off along with the prior mortgage and any other problems it came across. So the lender's okay, the owner is not, which is why the affidavit on page 6 is passed out at every single closing. It goes out with the commitment. The title insurance company invites you to complete it so that we can give some extra coverage that you otherwise wouldn't get. Okay? On page 6, you see number 3 of that affidavit. We simply ask the seller, has there been any repair, remodeling, or construction work done? And make a long story short, we pretty much take their word for it that there hasn't been any such work done, which strikes me as odd sometimes. They say we take their word for it on an extremely risky thing like this. Well, the fact of the matter is we don't have a history of claims on this. People generally don't lie in writing, and oftentimes they go way overboard to tell you, just because you shoveled the snow doesn't count as repair or maintenance work. Okay? So we ask the seller, has there been any work done? If they say no, then on the owner's policy, we also delete this exception. That's huge, okay, as an owner. I don't want to have the risk that there's going to be a lien filed. And it's very simple to get that cleared, and there's no extra charge for that. Number 1, rights of claims and parties in possession not shown by the public records. One of the other items on this affidavit on page 6, number 4, we ask whether or not there's anybody with any tenants in the property, because they probably aren't going to be recorded. You don't want to buy a house and find out there's a tenant living in there with an unrecorded lease. So we ask the seller, is anybody else living there that we have to worry about before these people take possession? We would also ask whether or not there's anybody using your property that as an easement that's unrecorded. Is somebody using your property consistently to get across to go to the lake or get to the hunting grounds? If that's something, we ask the seller to tell us things that otherwise would not be insured. And I'm running out of time, so the last thing I want to mention to you is surveys. One of the most frequent questions that I get is a survey required? And it's a difficult question to ask. But the answer is a survey required? The correct answer is by who? Okay? Best example is a friend of mine. I was at his house a couple of years ago at a barbecue, and he said, "Well, you're the title expert," and blah blah blah. I'm having an argument with my next door neighbor about the driveway over here. Where's my lot line, Jim? And I went over and I went, I don't know. Surveyors go out with laser beam and measure these things. We have no way of knowing this. People generally put up fences where they stopped cutting the grass last time, okay? Or where that tree is in a sort of line with the dog kennel. What's the chance of that fence being exactly on the lot line? Unless there was a survey done, which nobody ever does. Almost impossible, okay? The point is, people just live as neighbors most of the time without being concerned about these kinds of things. But if you and I are neighbors and we put up a fence, maybe together, it's not going to be on the line. Let's just take that as a given. Well, we don't really care that much, okay? But now I sell my house to somebody else, and you guys hate each other, okay? He goes out now and has a survey done and says, aha, your fence is 2 inches on my property. Move it, okay? Is a title insurance company going to take that risk? No, we're not, because no matter how much it costs to move a fence 2 inches, I don't care what it is, it's way more than the premium for the policy was, all right? Now, again, on loan policies, we will typically give that coverage anyways. Why do we do that? Because a lender is only going to suffer a loss when they foreclose and become the owner, and the value of their mortgage is so greatly diminished by this that they suffer a loss. Very unlikely. As long as mortgage payments continue to get made, a lender has not suffered a loss, and if there's a survey problem, this is not their loss. It could be the owner's loss. So the point is, number 2 on page 4 is a survey exception. Any encroachment, encumbrance, or boundary line dispute which would be disclosed by an accurate survey. If the garage is over the lot line, or the fence is over the lot line, or the whole house is over the lot line, that's not going to be recorded anywhere. And unless there's a survey provided, the title insurance company's position is, you're not insured for these problems. And frankly, whether you get a survey or not, we don't care. If you give us a survey, if you have a survey ordered, you give it to the title company. Okay? And an experienced title examiner who's experienced at reading surveys reads the survey, looks for encroachments or on boundary line disputes or adjoining property overlapping on us, and points them out to you before you buy the property by saying, the fence is 2 inches over the lot line. You're not insured for that. So now, before you buy the property, what do you want to do about it? You want to just live with that? Do you want to have the fence moved before you buy the property? Or do you want to set up a boundary line agreement between the neighbors? Okay, we recognize that the fence is not on the lot line. We recognize you have a prescriptive easement, or you have an easement to keep using it there. If it's ever torn down, it has to be put on exactly on the lot line. You know what I mean? We could fix this problem with some kind of agreement before the closing. But until there's a survey done, you're taking your chances. So it's a grown-up decision people are entitled to make. But somebody needs to point out to the owner that while the survey coverage is okay is being offered to the lender, it's not being offered to the owner. So either you pay for a survey, or you take your chances. It's a grown-up decision you need to make. So is a survey required? Well, since the lender is going to get that coverage, they're not requiring it. And since the title company's position is you're not insured for these matters, we're not requiring it. If anybody should be requiring it, it's the buyer. Now, if the buyer has borrowed every single dollar they can from the bank and their parents and doesn't want to spend another $500 for a survey, well, that's a grown-up decision they're entitled to make, but you got to understand that the survey coverages are not provided. All right? I think that's my time, and I thank you for your kind attention. And if I again repeat my invitation, if anybody has questions on any of these title matters or anything else, I would be glad to address them at any time. Thanks again.